Margaret, George, Esther, distinguished guests, ladies and gentlemen, first of all, may I express my gratitude to the Federation of Hong Kong Business Associations Worldwide for inviting me to this meaningful event and for giving me this opportunity to address such a distinguished gathering of business figures. For those who travel from overseas to attend the 15th Hong Kong Forum, may I wish you an enjoyable and fruitful stay in Hong Kong. In the past few months, various events in Hong Kong, including the so-called Occupy Central movement, have attracted much attention and discussions both within Hong Kong and beyond. One of the matters underlying these events is the constitutional development of the Hong Kong Special Administrative Region, the SAR, which focus on the selection of the chief executive through universal suffrage. In the course of the discussions and as events develop, issues concerning the rule of law have also been raised. In the circumstances, allow me to make use of this opportunity to share with you some of my thoughts on these two issues. Let me begin with the selection of the chief executive through universal suffrage. One of the key issues which has generated much debate is the nomination of candidates for the office of the chief executive. It is wholly understandable that issues concerning the nomination of candidates have given rise to debates or even controversies, as many other issues concerning the design of an election regime. However, like many other constitutional issues, issues concerning nomination of candidates should not and cannot be considered in a vacuum. Instead, the questions of nomination of candidates should be considered in the proper legal and constitutional context of the Hong Kong SAR. This is, if I may stress, of fundamental importance, since Hong Kong's status as a special administrative region of the People's Republic of China pursuant to the one country, two system is unprecedented in the history of constitutionalism as well as in the history of democratic development. To navigate this uncharted territory of universal suffrage in the context of one country, two systems, it is essential that we have a proper understanding of the chief executive's office as well as the role of the Central People's Government, the CPG of China. In this regard, the provisions in the Basic Law and the relevant interpretation and decisions made by the Standing Committee of the National People's Congress, that is the NPCSC, are highly pertinent. Article 15 of the Basic Law provides that the CPG shall appoint the chief executive and the principal officials of the executive authorities of the Hong Kong SAR in accordance with the provisions of Chapter 4 of the Basic Law. Chapter 4, of course, is the chapter in the Basic Law which deals with the political structure of the Hong Kong SAR, and the most relevant provisions for the present purposes are Article 43, 45, and 48. Article 43 stipulates that the chief executive, as the head of the Hong Kong SAR, is accountable to both the Central People's Government and the Hong Kong SAR. Article 45, which is perhaps the most pertinent provision for our present purpose, provides as follows, and if I may quote, "The chief executive of the Hong Kong Special Administrative Region shall be selected by election or through consultation held locally and be appointed by the Central People's Government. The method for selecting the chief executive shall be specified in the light of the actual situation in the Hong Kong SAR and in accordance with the principle of gradual and orderly process. The ultimate aim is the selection of the chief executive by universal suffrage upon nomination by a broadly representative nominating committee in accordance with democratic procedure. The specific methods for selecting the chief executive is prescribed in Annex 1, which is the method for selection of the chief executive of the Hong Kong SAR. Annex 1, as it now stands, provides the chief executive shall be elected by a broadly representative election committee comprising a total of 1,200 members from 4 sectors. Paragraph 7 of Annex 1, which is also highly relevant, provides as follows, and if I may quote again, if there is a need to amend the method for selecting the chief executives for the term subsequent to the year 2007, such amendments must be made with the endorsement of a 2/3 majority of all the members of the Legislative Council and the consent of the chief executive, and they shall be reported to the Standing Committee of the National People's Congress for approval. Article 48, on the other hand, deals with the powers and functions of the chief executive. One can easily see from the various provisions in Article 48 that the powers and functions of the chief executive are very wide and extensive. Based on the provisions of the Basic Law, the NPCSC has previously dealt with the issue of universal suffrage by, firstly, an interpretation made on 6th of April 2004, a decision made on 26th of April 2004, and a further decisions made on 29th of December 2007. Put shortly, the effect is that amendments to the method concerning the selection of the chief executive have to go through a 5-step process. First of all, the chief executive to make a report to the NPCSC so as to invite the NPCSC to decide whether it is necessary to amend the method of selection or formation. Second, the NPCSC to make a determination on whether any such amendment shall be made. Third, if the NPCSC determines that amendments shall be made, the Hong Kong SAR government is to introduce to LegCo a resolution on the proposed amendments to be passed by a 2/3 majority of all LegCo members. Fourth, the chief executive to consent to the resolution as passed by the LegCo. Fifth, and which is finally, the CE to lodge the relevant bill to the NPCSC for approval. From this very brief survey of our constitutional regime, it is clear that the CPG, the Central People's Government, has a role to play in the constitutional development of the Hong Kong SAR. Not only does the NPCSC have the power to decide whether to approve the bill for amending Annex 1 to the Basic Law, which sets out the method for selecting the chief executive, the CE-elect, the chief executive-elect, ultimately has to be appointed by the Central People's Government. And this power of appointment is a substantive as opposed to a nominal one. This is because Hong Kong is not a sovereign or independent state, but a special administrative region of the PRC. Besides, as I noted above, the chief executive has to be accountable to both the CPG and the Hong Kong SAR. Further, it is equally clear that there are two important dimensions to the future election regime. The first concerns the election by eligible voters pursuant to the one person, one vote principle. The second concerns the appointment by the CPG. As pointed out just now, Article 45 of the Basic Law provides that any chief executive-elect shall be appointed by the Central People's Government, and this power of appointment is a substantive one. In other words, the Central People's Government may either appoint the chief executive-elect or, in appropriate circumstances, decline to make an appointment. Taking into account all these matters, the future system for selecting the chief executive by way of universal suffrage has to address and handle these two dimensions in an appropriate and effective manner. Failure to do so might turn the future system for selecting the chief executive by way of universal suffrage into a recipe for constitutional crisis. The decision made by the Standing Committee of the National People's Congress provides the framework to deal with these two dimensions. Besides, it is clear that both the government of Hong Kong and the CPG share the common aspiration to attain universal suffrage for the selection of chief executive in 2017. The challenge we now face is how to address the divergent views within the community so that we can agree on an election system which is acceptable to all the stakeholders. When universal suffrage is put in place, it is estimated that about 5 million voters will be entitled to take part in the selection of the chief executive. Viewed from any angle, the election of the chief executive by one person, one vote, will necessarily be a significant step forward and will certainly be a system more democratic than the current system of the election of the chief executive by the election committee. Besides, the election of the chief executive in 2017 by universal suffrage is just the first step. Paragraph 7 of Annex 1 to the Basic Law and the 5-step process mentioned earlier provide the legal avenue for future refinement of the system when sufficient support from the community exists. Let me move on to the rule of law. Hong Kong, as we all know, is a jurisdiction which attaches great importance to the rule of law and the concept of judicial independence. In this regard, I appreciate that comments, including sometimes adverse comments, have recently been made about the state of the rule of law in Hong Kong. However, if I may be permitted to be blunt, all those assertions which sought to suggest that the rule of law and judicial independence in Hong Kong are being eroded are no more than mistaken perceptions. I would invite you to consider not just bare assertions, but to consider objective circumstances which point to the opposite direction. From the constitutional perspective, the rule of law and judicial independence are firmly guaranteed by our basic law. Among others, Article 2 and 19 of our basic law provide in no uncertain terms that Hong Kong enjoys independent judicial power, including that of final adjudication. Further, Article 82 of our basic law provides that the power of final adjudication of Hong Kong shall be vested in the Court of Final Appeal. One important aspect to note is that Article 82 puts in place an unique arrangement which permits the invitation of judges from other common law jurisdictions to sit on our Court of Final Appeal. Since the establishment of the Hong Kong SAR in July 1997, eminent judges and juries from the United Kingdom, Australia, and New Zealand have been invited to sit on our Court of Final Appeal. As a matter of fact, final appeals of all types of cases, including cases raising important constitutional issues, proceedings touching on important government policies, as well as substantial commercial cases, were and still are being heard by a panel of 5 judges, which invariably include one such overseas judges. At the moment, we are privileged to have a total of 12 such overseas judges sitting on our Court of Final Appeal from time to time. They include familiar names such as Sir Anthony Mason, Knott Neuberger, and Knott Hoffman. It is, if I may say, beyond imagination that these eminent judges will be willing to sit in our Court of Final Appeal if they do not enjoy judicial independence. It is, if I may say, equally absurd to suggest that these eminent judges would remain silent if they ever felt any form of interference in the discharge of their judicial duties. The fact that Hong Kong can continue to attract such eminent overseas judges to sit in our Court of Final Appeal is a strong testimony to the state of judicial independence and the rule of law in Hong Kong. Besides, the judgments of our Court of Final Appeal are highly regarded in other common law jurisdictions. This is illustrated by the fact that its judgments are regularly cited and relied on in leading common law jurisdictions such as the United Kingdom and Australia. The Hong Kong SAR government fully appreciates the importance of the rule of law, whether for the purpose of her economic development or for the purpose of protecting fundamental human rights. The Hong Kong SAR government will make every possible effort to maintain the rule of law and judicial independence. Ladies and gentlemen, it is true that Hong Kong is currently facing significant challenges. However, as we would also recall, Hong Kong has in the past overcome many challenges, including the SARS in 2003 and the various economic turmoils. With the strong fundamentals that Hong Kong enjoys, and with the common aspiration to maintain Hong Kong's prosperity and stability, we have every confidence that Hong Kong will also overcome the current challenges and will continue to be one of the leading international financial and commercial centers. On this note, if I may wish the Federation of Hong Kong Business Association worldwide and each of you here every success in your future endeavors. And for our overseas guests, if I may again wish you a pleasant and enjoyable stay here. Thank you very much.
Thank you, Secretary for Justice. Please remain on stage. May I invite Ms. Margaret Fong, Executive Director of Hong Kong Trade Development Council, to come onto the stage to moderate the question and answer section for us. Ms. Fong, please. Meanwhile, if you have any questions for the Secretary for Justice, please pass your question paper to our staff.
Right. Thank you very much, Mr. Yuen. If I may start with the first question, is that you have already explained very clearly all the clear provisions in our mini constitution, the basic law, on the steps to be followed to achieve universal suffrage for the election of the chief executive. That's very clear, but there is certainly a group within the community, and a very vocal group too, who may disagree. So how do you see that happening in terms of going forward? How confident are you of arriving at a consensus which can actually allow us to move forward to have universal suffrage for the election of the CEE in 2017?
Yes, thank you for that question. I think you are perfectly right to say that there are groups within the community which may take a different view, or perhaps a very different view from what I have said in the course of my speech. But I think at the end of the day, I hope that people who are trying to attain universal suffrage would respect the spirit of democracy, which includes respecting the views of those who differ from them in the community. In fact, in Hong Kong, I think through what we can see in the media, as well as various opinion polls, I think there are, in fact, a substantial portion of people in Hong Kong who remains aspired to attain universal suffrage in Hong Kong on the basis of the basic law and the various decisions made by the NPCSC. Of course, we need to have rational communication, rational discussions, so that the majority of the people in Hong Kong would agree on the way forward, which of course is the important things to do. And I hope in the event, subsequently, that we can achieve a certain consensus within the community those who take a different view would also respect the will of the majority. In particular, those who are members of the Legislative Council would respect the views of the electorate and therefore vote accordingly when the bill is to be introduced to the Legislative Council.
Thank you. This is a question from the audience. They're asking that I think what is happening in the Occupy Central movement actually shows that there are perhaps pretty divergent views between the political and the judicial system or the legal system as to what they believe would be the right values for this society in Hong Kong to emulate towards. So what are your views on this?
I think, first of all, it's important to stress, as the judges have recently reiterated, that judges decide cases on the basis of the evidence before them and in accordance with the law. Judges do not take into account political views or political development. That, I think, is the first and foremost important point. And point number two, if I may say, is that when one wants to express their political views, irrespective of whether it agrees with the majority or differs from the majority, they have every right to do so. In fact, our system of law allows them and guarantees such right of expression, but they have to do it lawfully and within the legal boundary, because by so doing, you are not only respecting the rights of the others, but also respecting the spirit or the concept of the rule of law. If I may say, the concept or the rule of law concept is as important as democratic development. In fact, it will be difficult to see how one can have democratic development without the rule of law. Therefore, whatever aspiration in terms of political causes or universal suffrage, I would say one still have to act in accordance with the law, including when a judge or when a court has made a decision that has to be respected and obeyed.
Thank you. This is a question from someone from Germany. He's asking about the white paper that was issued by the People's Republic of China a couple of months back. He is interested to hear your views on how this is viewed from the legal point of view, from where you're sitting, and also the remarks that judges shall inter alia also be administrators.
Yes. Insofar as the white paper is concerned, I appreciate that after it was published sometime middle of this year, it has generated considerable discussions. There have been suggestions that it would be having a negative impact on the rule of law in Hong Kong. I take a different view, and if I may, without going into the details, if I may again draw to your attention certain objective observations made by not me as the Secretary for Justice, whom you may say I'm bound to defend this way or that way. But if I may draw to your attention, perhaps the most important one is the speeches made by Lord Neuberger, the head of the Supreme Court of the United Kingdom. When he was in Hong Kong, he in fact delivered a speech in Hong Kong about the rule of law situation and with specific references to the white paper. At the end of the day, he effectively say he wondered whether there was anything to worry about in the white paper published by the State Council. On the point that you mentioned about judges, in fact, quite recently, just a couple of days ago, if not last week, in fact, similar remarks have been made in the course of the certain debate in the Parliament in UK, where one of the persons said, well, in fact, one would have the same expectation about judges of the United Kingdom. In a way, in fact, if you look at the oath of allegiance sworn by judges in Hong Kong, and they are in fact the same, effectively the same as those sworn by judges in UK. And to be patriotic, that is the same requirement as explained in the white paper.
Thank you. I have two questions come from, I think, quite different points of view. One represents views from USA and somebody from Australia. The first question is why the police are not taking enforcement action to remove the occupiers, because obviously they are unlawful acts there. The other question asked about the legal implication on the three organizers of Occupy Central who will be turning themselves in this afternoon, and what would also be the legal implication for the mass public who were involved in the whole movement. So two quite different questions. Your views, please.
Can I have the first question?
The first is why the police not enforcing the law when it is certainly clear to many people that the occupiers are already illegally occupying the areas they are now.
I think as Margaret has very cogently put it, these two questions are asked from two perhaps very different, if not diametrically opposite angle. And that illustrates the very fact that as a responsible government, we have to consider different, if not divergent views when considering whether, and if so, when to take action. In the past 2 months or so, the government has been adopting a tolerant attitude. And as the chief executive explained yesterday, we are being tolerant not because we do not have the power to take proper enforcement action. It's because we do not want to see unfortunate events occurring in the course of enforcement action. But that doesn't mean that enforcement action will not be taken, although, of course, I'm not at liberty at this stage to divulge the details of whatever plans we have. And insofar as the second question is concerned, that is the 3 persons, or perhaps as they say, more than 3 persons will be turning in this afternoon. I think we will have to wait and see as to exactly what happened this afternoon before we can tell how the police would deal with it. I don't think I should say too much at this stage.
Okay, right. I think we have answered all the questions that I have on hand, and I hope that what you have all heard this afternoon from Mr. Yuen is that rule of law is alive and well in Hong Kong, and that Hong Kong remains a place which is your best bet in accessing opportunities in the whole region in Asia. And we believe that if there is one defining philosophy in Hong Kong, it's the rule of law. And this is a value that not just the government, but I think all the business community in Hong Kong and all Hong Kong people will work hard to preserve. So with this, please join me in a warm round of applause for Mr. Yuen.